Okay, we may as well start. What I'm proposing to do this week is to finish off Article 101, material on Article 101. We're just about there. We need to finish off cartels and bad horizontal agreements. We'll then turn to vertical agreements and the antitrust, the competition treatment of them. And then finish with a discussion of sort of less harmful horizontal agreements and their treatment in the block exemptions. So that'll be the task for today and tomorrow, meaning that next Monday we will start with Article 102. Okay? We were discussing last time the nature of cartels, and because of their pernicious, their really harmful activity, the hardcore cartels, price fixing, market sharing, output reduction, etc., they really have no redeeming purposes. Any antitrust regime will will treat these very severely and harshly. The Commission sets, if you're involved in a cartel, and unless you cooperate, we will get to that in a few minutes, unless you cooperate, you can expect to be fined. Now, the Commission has a guidelines on how they set fines. That can be found in the first volume of that collection of materials, and the fines, essentially you look at the basic amount, that you calculate sales in relation to the affected product, you come up with a basic amount, and then paragraph 22 of that document gives some suggestions as to how or what factors should be considered when calculating the basic amount. Horizontal price fixing, market sharing are the most serious, so you can expect the basic amount of such cartels to be higher than other cartels. The basic amount is then adjusted upwards and downwards. Upwards by considering aggravating circumstances. In other words, is this a really bad cartel? Have during the investigation of the cartel, has the undertaking, or in particular its employees, misled the Commission? Has the undertaking been involved in similar cartels or even cartels in the past? Then, of course, mitigating circumstances, things such as cooperation, the fact that it's a smaller undertaking that may have been coerced into it. We go in here. Deterrence, both general and specific. What kind of message does the Commission need to send to both the undertaking involved and the and other undertakings about this sort of behavior? Legal maximum, and then afterwards they checked for a legal maximum. That should be 33, not 23. Check for the legal maximum. The legal maximum is set by Regulation 1/2003, and that's 10% of the undertaking's previous year's turnover. Then the provisions of the leniency notice, which we'll get to in a couple of minutes, are applied, and then finally, ability to pay is considered. And we'll see this in a moment. The Commission is not in the interest of driving undertakings, even if they were involved in pernicious cartels, driving such undertakings into bankruptcy. And the public sanctions, they can look quite serious. 2015, we showed a little bit here, and then 2019. It's been nothing really since the 27th of September. Just under 1.5 billion euros. The Commission's focus in the last few years has been away from cartels 101 violations towards 102 violations. Okay? These amounts have been adjusted for court decisions. In other words, sometimes fines are reduced on appeal. The reason for it being reduced on appeal is that the Commission takes into account the wrong factors, or alternatively somehow misapplies their own guidance on how they set fines. Remember, guidelines, Commission guidelines don't bind the court, but they bind the Commission. And if the Commission has said that they would adhere to a guideline, but it looks like in their fining decision they haven't, then of course the undertaking has an opportunity to take this before the European courts. Generally speaking, almost every Commission fining decision is appealed. Okay? With that kind of money, let's be honest, it's worth an appeal, right? Because even if it is reduced by 10%, Commission pays the legal bills and you get a large savings. Okay? So that is other work for competition lawyers appealing fine decisions. Now, as I pointed out last time, the fines can appear to be substantial. 2006, the trucks cartel, that was they were fixing the market on large trucks. And Delmer was the leading participant and was fined over €1 billion. They can appear to be substantial, but are they substantial enough? Okay, and to this end, we looked at a little bit of Gary Becker's insight. Gary Becker was one of the leading members of the so-called Chicago School, the law and economics approach. Looking at economics, at the insights that economics can provide to an analysis of legal problems. And his insight was that if the cost of an activity is greater than the expected benefits of the activity, a rational individual, and here thinking about rational individuals, corporation is a profit maximizing entity, so that's often viewed as a paradigm of a rational individual. So the rational individual will not engage in that activity, right? You're not going to, engage in an activity the cost of which is greater than the benefits. And his insight was crime, and criminal type behavior is one such activity. His manner of thinking, as I mentioned, came about when he had to, when he was rushed for an appointment and had to consider, couldn't find a parking space, so had to consider the probability or the possibility of parking illegally. And his insight was that if if you're in a situation, say, where the parking fine is £50, you've got a 10% chance of detection. Therefore, the cost of the illegal parking is £5. So if making the appointment on time, and of course the price of parking was valued at more than £5, then it would be rational to take that risk, right? Notice, parking, nobody views illegal parking as some sort of morally heinous activity, right? You may want to, the analysis may break down when you're talking about, things such as theft or murder or assault or something like that. But Becker's analysis applies here. Okay, now the problem is with cartels, and a lot of people really don't think that cartels, especially those who are participating in cartels, don't view them as particularly morally heinous. So again, a cartel fine may well be like a parking fine. Okay? Now, the problem is, so what you have to do is assess the expected value, or how much is it worth it to go into a cartel versus what are the consequences, i.e. how much of a fine would I have to pay if I were caught. And I looked at some statistics going back about 30 odd years. The overcharge in a cartel, that is to say how much extra the consumer pays, typically ranges between 25 and 35%, sometimes as low as 10, sometimes as high as 50. The average length for a cartel is somewhere between 6 and 8 years. Okay, the mean is about 8.8, the median is 6 years, which means that about 13 to 17% of cartels are detected in any given year. Okay, so the deterrent fine for a year is somewhere around 260, somewhere between 147 and 270%, 269% of the overcharge, the takings. Now, if that's with an 8-year life, an average fine needs to be somewhere over 1,000%. Yes.
Yes. Should we do the calculations on the exam?
No, you'll never be facing this. The exam, you see on the exam, you'll see calculators are not allowed. Okay, for a reason. Okay, you'll never be given a question on an exam where you have to do the calculations. If there are calculations necessary, I will give you the answer, okay? Calculations, the only circumstance you will see calculations is when we get to merger control, where we're talking about the difference in HHI, which I will give you, okay? And then that should feed into what you know in the answer. This is not an arithmetic exam. It's a law exam, okay? Okay, so the fines need to be somewhere around 10 to 20% of a year's affected, 10 to 20 times a year's affected commerce, not 10%. Two problems though, if you whack a company with that kind of fine, bankruptcy is an inevitable consequence. Yes?
Here's where I get lost. Like, I understand, for example, like, it was a bank crash, there's consequences to the general public. But why does the commission care, for example, Hasbro goes bankrupt? It's not like...
Okay, Hasbro employs people, right? Where do their jobs go? Look at Delmer, the truck manufacturer. Delmer employs people. Delmer, so all of its employees go. But Delmer's at the end of a supply chain. Okay? Typically, these industries are located in an area. Knock-on effect, right? Somebody working for Delmer spends their paycheck. Okay? That has a, economists have a sort of a multiplier effect. If somebody earns £1 because they spend it, it's about sixfold, right? You go buy groceries, the people in the grocery store, the grocer buys it in a supply chain, its employees, so on and so forth, okay? So it's those massive consequences there of putting a plant down. Similar to the effects we saw mitigated in, remember when we were talking about 1013 and the Dutch brick industry and the polyprop industry? They were trying to close down in a way to mitigate all of these problems. Okay, so bankruptcy is not a consequence for Dahmer, but it's a consequence of people that depend upon Dahmer to earn a living. Okay, the person on the assembly line, the truck assembly line, is completely innocent in terms of any price fixing there. Okay. So the commission takes ability to pay. About 9 years ago, almost to the date, the Deputy Director General for Competition points out that there were some serious infringements in 2010. Right, this is just sort of after the economic crash, and of course, as Mr. Lumina, he was the former competition commissioner. Our aim is not to put companies out of business. So we've taken into account valid claims for inability to pay. On 10 occasions, they reduced the fine that the companies could afford to pay. But as economic recovery picks up, right, this was 2010, so after the crash, we foresee that such circumstances will be increasingly rare. Okay, so if there's a legitimate reason, and they'll want to see the books, the audited accountant statements, that an undertaking can't pay, fines will be reduced. The same thing happens at the national level in the UK. The CMA will reduce fines to undertakings that legitimately can't pay. Finally, the leniency program, okay? There's, I think, two consequences of this. The first consequence is the reduction of the fine, going into the fine calculation that we saw earlier. And the second is how it reduces cartel stability. The details are in this commission notice on immunity. That's also in volume 1 of those documents. And essentially, the key thing about this is that the first undertaking to come to the commission, confess membership in a cartel, provide the commission with details about the cartel, and cooperate, gets absolute immunity from a fine. 100% reduction. Okay? Subsequent other undertakings, they qualify if they provide significant added value. In other words, evidence that's really useful. The second one in, somewhere between 30 and 50%. Third one in, 20 to 30. And others up to 20%, yes.
Yeah, so what's the meaning of this significant added values?
Well, how good their evidence is, okay? Does it, if it just duplicates what the first undertaking says, not much, 30%. If it gives other information that is not found in the first undertaking's evidence, pointing to other members, then that's can be significant. Okay, so it's, how useful is it in investigating and prosecuting this cartel? Yeah, but yeah, you're right. It is a bit vague. Okay, now the real problem, or not the real problem, the real benefit, okay, of a leniency program is that it injects an element of distrust into cartels. Okay? Cartels, by their nature, have to be secretive, right? They're basically nothing more than a conspiracy. Okay? They're a group of people secretly agreeing to commit a very serious offense, a crime in a lot of jurisdictions. Okay? The worry, but the other thing is, a cartel works only if everybody keeps to the bargain, keeps their side of the bargain. Okay? If somebody doesn't keep to their side of the bargain and undercuts the cartel price, then they gain at the expense of everybody else. So cartel members' first worry is, are my fellow conspirators cheating on me, going behind their back and offering reductions, secret discounts? Okay? So there's already that element of distrust. Remember in the Treuhand case, right? That Swiss company that organized cartels mediated concerns and dealt with difficulties when one company felt that another company was cheating on the cartel. Okay, so that's a problem. The second problem, though, and what the leniency program does, it adds a further element of distrust. Oh, if relationships get really bad, is one of my fellow conspirators going to go to the authorities and turn us all in? Okay? They get to go, they get a free pass, get out of jail free card, to use the Monopoly game analogy, and I get stuck with a fine. Okay? So there's always that. Now, it's been argued, okay, I guess two things we can point out before I say. First of all, actually three things. First of all, from a historical point of view, this idea of immunity came in from the States. The Department of Justice would do it, usually and it's just a way of their criminal investigation, giving an informant a free pass on prosecution. The second point to be made is that in Europe, this is how most cartels are uncovered. Okay. Somebody, for whatever reason, reports it to the competition authorities. Whatever the reason is, unlikely guilt, fear that somebody else is going to do it, so they want to get in first. Could be a change of management, possible sale of the company and somebody's doing due diligence, etc. There's a number of possible reasons, but this is the how should we say, the leading means by which the Commission finds out about cartels, and also by which we find out about cartels in the UK. The third point, though, is that this can be gamed. Okay, there is some suspicion that some undertakings, some commentators have suggested that the French petrol company, French oil company Total, games the system by entering into cartels, and then one of its subsidiaries giving it up. Total walks away without a fine, scooping the profit. Everybody else is stuck. Okay, so it is open to some gaming, but the Commission is aware of this, and I think fully recognizes that this happens, but is willing to put up with a limited amount of gaming, so to have the advantage of getting information for other cases. Now, having said this, there are some agreements, horizontal agreements, that are good. We're going to get to this after we talk about vertical agreements. Agreements between companies for research and development, marketing agreements, cooperative buying agreements, all tend to be good. The Commission takes these into account and in effect not pre-approves, but says we're not going to examine them, and does so by issuing some block exemption regulations and some guidance. We'll get to that tomorrow. Okay. If it falls out of the block exemption, 103 analysis is appropriate. But that's for tomorrow. Any questions about cartels at this point?
Yes, I want to ask which one is better, the leniency programs or the normal one?
The normal one?
Yeah. The normal is that the cartels charge fines.
Right. But the leniency, you see, leniency goes into assessing the fines. Okay. You see here, okay, that should be, as I said, 33, not 23. So the Commission will set a fine, okay, and then make adjustments to the fine, aggravating, deterrence, apply a legal maximum, and then apply the leniency notice, okay? So it'll go through and say that, blah, 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 so on and so forth, so on and so forth, but you were the second one in, and we'll come up with a number here at this point and say you were the second person in. You did provide information that was of sufficient added value, So we're gonna chop your fine by 40%. Okay, so it's a step in there, and the leniency guidelines say how it's applied. Okay.
My question is, so I get how the leniency program works in the sense that, for example, if I report membership to my cartel,
Right.
or I purchase a company and I see it's part of a cartel and I sort of, well,
Not just sort of.
Yeah.
You email the commission. Yeah.
well, what happens if, how does the leniency program work, or maybe just it doesn't take effect, if someone who isn't a part of a cartel uncovers it? Like, they're not a party to it. There's just no leniency there at all?
There's no leniency for anybody. Okay, and this can often happen. Let's say a
Undercover reporter.
no undercover, or the other way is a customer. Okay.
Okay.
Suppose you're in a market. Okay. Pre-cartel. You notice either a difference in price or a similarity in price, but competition among the various dealers to sell to you. Okay? Then a period of time passes. You notice fairly similar prices, but only one dealer is willing to sell to you. Okay, that's a tip-off that they're fixing prices and perhaps allocating customers, whether it's geographically or by type of customer. You get, okay, whatever, you buy it, buy the good at that, and then, you need to buy it again, or, the supply contract comes out, same thing. You think, this is weird, what's changed? Okay, and then in the back of your mind, you might think that maybe there's some cartel out there, so you go and you report it. Okay, to the relevant, whether it's the CMA or the commission. The commission takes, depending on work resources, they consider this. Get a few reports from a few customers in the industry. Commission might act, or alternatively, the CMA sees your report and uses it. Well, why don't I talk to other buyers, similarly situated companies in the industry, and see what's going on. If they all report the same thing, that gets suspicious. You might want to look at historical trends and the like, develop a theory of what's going on, use that to convince a judge or the commission to give you a search warrant. Take a dawn raid and see what's going on. Okay. But the customer gets nothing out of it.
No.
Okay. Some jurisdictions put a bounty on cartels. Okay. Not in Europe, not in the U.S. Korea puts a bounty on cartels. If you uncover a cartel, you get part of the fine. So it incentivizes customers to report. It incentivizes employees to turn the... Okay. Bounty might work. I mean, former FTC commissioner suggested that that's a really good approach and the U.S. should adopt it. Okay. So, any other questions on cartel behavior? No, good. Okay, then we'll move to verticals. Slideshow from current slide. Okay, vertical agreements. What you'll need to do is, in addition to looking at the material in the texts, go to the second volume of the rules, right, the 2 volumes, and you'll see the end, part B, vertical agreements. There are 3 documents. One's council regulation on the application. Don't necessarily stress about the first one, but you should look at Commission Regulation 330, 2010 on verticals, and guidelines on verticals. Guidelines on verticals. That's at page 108 of this commission publication. Guidelines on verticals is quite important. So read that, print it out, read that, bring it to the exam. Okay? Because you can answer most vertical agreement questions with a copy of the guidelines on verticals next to you. Okay, so that's why I say it's important. Read it, familiarize yourself with it, and I would recommend bringing it to the examination. Okay? Is that sufficiently enough of a hint? Bring it to the exam. Okay? Okay, now, what's a vertical agreement? Okay, a vertical agreement is an agreement made between two undertakings at different stages of the supply chain. Okay. This contrasts with horizontal agreements that are agreements made by undertakings at the same level of the supply chain. Okay. There is a great deal of thinking, microeconomic thinking, about vertical agreements, and the suggestion is, based on this thinking, that vertical agreements are less harmful to competition than horizontal agreements. Okay. The reason for this is that vertical agreements will typically involve only one brand. Sort of one manufacturer having a agreement with a distributor of that manufacturer's goods, or a wholesaler, or a retailer. But typically they affect only one brand of goods. Okay? However, and no, typically they're only one brand of goods, and there are other brands of similar goods which are sufficiently substitutable so that those involved in a vertical agreement can't do something that's highly anti-competitive. Because if they do something that's highly anti-competitive, it will raise the price for that brand of good, and that brand will be eaten alive in competition with other substitutable brands. You see that? It's the pressure of other brands that prevent that. In horizontal agreements, typically they're among producers, or they're among people involved in the manufacture, sales, distribution, whatever, of goods of different brands. So it knocks off that competition among brands. So that's why horizontal agreements are tended to be viewed as more harmful than vertical agreements. Okay? Take for an example. Suppose you have a manufacturer of cars. Let's see, what do we have? Let's see, we have Toyota, Nissan. Yeah, Toyota and Nissan's all we need. So suppose Nissan does something in their distribution arrangements, in their vertical arrangements, that cause the price of their goods to rise. So people who would otherwise have bought Nissans will possibly switch to Toyotas, right? Okay, so Nissan can't. So that there's a pressure there on Nissan not to engage in that kind of activity. Okay. Vertical agreements typically are concerned with the distribution question. How does a maker of a product, a manufacturer of a product, get its product to the consumer? Okay. And there are a number of considerations in doing this. Okay. Costs or efficiency are among them. Okay. So you can either do it yourself, in other words, vertically integrate. The manufacturer has, dealers over whom they have exert a significant degree of control, and that's sold on to the consumer. or you can get somebody else to do it. You sell it on to somebody who then in turn sells it on and then sells it on. Okay? This is a similar issue to what we will see when we get to vertical mergers. Okay? Some mergers are driven by this. And there's similar consideration with supply or acquisition of the inputs to the goods. The manufacturer needs raw materials, so they can either produce the raw materials themselves or they can buy the raw materials from someone else. Okay? So it works all the way. Now, there are often other parameters. Okay? Quality is perhaps one, and control over the merchandise and the conditions under which the merchandise is sold relates to quality. Quality is a significant parameter in the luxury goods market. Okay? A lot of cases that we will see come out of the luxury goods market. Okay? Because luxury goods, in addition to being being perceived or having certain intrinsic qualities, a higher grade of, say, leather for a handbag or cloth for a blouse or a suit. Okay, they also have an image, an allure. Okay, which a lot of quality goods producers, quality goods manufacturers want to preserve by having their goods sold in the right kind of stores. Right? Example. If you go down to London, walk along Bond Street and look at the right those stores. Okay? Then walk into Primark. Just walk around to Oxford Street and walk into Primark. See the difference. Okay? So the manufacturer of some of these luxury goods is going to want that Bond Street experience for their goods and the customers of their goods, as opposed to the Primark experience. Nothing wrong about Primark, but it's not a Bond Street experience. Okay, if you want a pair of inexpensive socks when you're rushed, Primark's probably the place to buy it, I think. Okay? So, there's always a problem with control of doing it, costs, and market expansion. Now, going on to this, distribution agreements. How can suppliers get customers to purchase their goods? That's ultimately what, manufacturers aren't making these things for nothing, right? That needs to be sold on to consumers. The distributors or retailers will provide shelf space. Okay, stock, ability to sell it. Competition for shelf space is very interesting. In the grocery industry, competition for shelf space is fierce. Not just shelf space in linear feet, okay, but also shelf space in terms of positioning. Okay, from a marketing perspective, where are the best? Does anybody know where the three best places in a grocery store are?
Eye level.
Pardon?
Is eye level one of them?
Eye level is one of them. Typically, put the goods with the greatest margin at eye level because people see that. Higher up and lower up are the goods with lower margins. So typically you'll have, if you're in the beans aisle, you'll have the Heinz beans or whatever right there, and then the own brand right at the bottom. Okay? Other areas are at the end of the aisles that people have to walk around, particularly eye level, and also at the near the cash desks for those impulse purchases. okay, for smaller impulse items. Okay, now, suppose I don't know, let's say a distributor or manufacturer of, let's say, potato crisps. How do I get my goods at eye level as opposed to the bottom line? Or how do I get 4 feet of shelf space instead of 3 feet of shelf space?
Pay a lot.
Pardon?
You just pay them more.
I pay them. Exactly. I can do it 2 ways, by giving them a better margin on the goods or a straight cash payment. Grocery industry likes straight cash payments for that. Okay? I don't know if you've been following it, but in the autumn, a couple of Tesco executives, Tesco got into some trouble with some accounting irregularities, and were booking that sort of payment as money that they received in one quarter, when in fact they weren't going to receive it until the future. So they were rigging their books a bit. It's called a slotting fee. That's what it's known as. Okay, so distributors, one way or another, provide shelf space. The way of doing that is if you're just distributor, retailers, whatever, provide shelf space. One way of keeping your goods in stock is to keep your retailers happy. Pay them or somehow keep them happy. Retailers also provide pre- and post-sale service, right? It may not, potato crisps, not really an issue. Try buying something moderately complicated, a mobile phone, computer. Some electronic gizmos are quite good, okay? Pre-sale service, which should I buy? Post-sale service, a week later, I can't figure out how to do it, right? You go to the retailer. This could be important, and we'll get to that. We'll focus on that as well. Suitable premises, brand image. This is the Bond Street experience that I mentioned, okay? The retailer, the manufacturer wants their goods sold in an appropriate premise, okay? Finally, promotional efforts. Okay, the manufacturer may want the distributor to be involved in promoting the product, may want if there's a sale happening, or the manufacturer may want the distributor to cooperate in this sale. Okay? Now, the problem is the dealer or the retailer, if they're independent, is out for themselves. Okay? And typically wants to make money as easily as possible. Okay? And you often get what's known as a free rider problem. If you're a retailer, your incentive is to free ride on the efforts of others. Okay? Let them spend time, money promoting the manufacturer's goods. Let other retailers, salespeople discuss the pros of the relevant mobile phone or computer. Let somebody else's staff answer the week after purchase inquiries. I'll just sell the goods, and maybe just so that I can sell more goods, I'll sell them at slightly less than what everybody else is selling them for. Okay. So, to solve this, you need to somehow, although you keep your retailers happy, but limit competition among them. Okay. And there are ways of limiting competition. Okay, some of these are legal, some of these are not necessarily legal, some of these are in that gray zone.
Yes, I quite don't understand like why this free ride can limit competitions. Like if I am the retailer, I think it's quite normal to pay a free ride to
Well,
from the manufacturer.
oh wait, look. Problem is, okay, and this free riding, it really comes up in when we get to the resale price maintenance issue. Okay, that is to say minimum resale prices. Okay. Problem with free riding, okay, is that what happens. Okay. Suppose you're a full-service phone shop. Okay, mobile phones, right? You're a full-service. You have a display of the goods. Your salespeople are knowledgeable about the products, and they can, converse well with a prospective customer. And if a prospective customer comes back a week or two later, they can address the problems. Okay. You probably have a certain sort of premises that allows for the display of these. Your staff is all trained on the sort of intricacies of the various models of various mobile phones, knows each phone and knows how to do whatever on the phone. So these premises and training your staff in that way has cost you money. Okay? Now, a manufacturer is going to like that, okay, because, okay, the manufacturer knows that the customer comes to this particular store. The customer, will have it nicely explained, good shopping experience, and then if there's a follow-up problem, it'll be dealt with promptly and nicely. So the manufacturer's happy, the retailer is probably happy, and the customer is really happy. Customer will then in turn probably recommend it to friends, so on and so forth. Now the problem is, so that's all fine. Now the problem is, suppose next door to your shop with a fully trained staff, there's Discount Mobile Phones. Little sort of really, one guy behind the counter, he's got phones, you have to ask for them. You throw them the money, he throws you the phone, and it's, something off, so go away, okay? Now, Discount Mobile Phones is selling at 30% less than your full service store. What's going to happen is customers are going to go to your full service store, talk to your salespeople, whom you've paid to train. Okay, maybe enjoy that coffee while talking to the salesperson. Then say, let me think about it, I'll be back in an hour. Go next door. Okay, so you're providing all of that as service, but you're not getting anything in return. Okay, you're going to go out of business fairly fast. Think bookstores and Amazon. Right? Remember the old days? You could go into a bookstore, look at a few books, sit down in a comfy chair, look at a few more books, then go buy a book. Bookstores are dying. Okay? They really are, and it's a shame. It's a cultural shame.
Isn't that just what Amazon is, though?
Well, we
Like
can
you say, let me check online, and it's almost always cheaper online.
Yeah, but it's cheaper. Why is it cheaper?
They don't provide that service.
For a couple of reasons. One, they don't provide that service. Okay? And secondly, they may be predatory pricing in some aspects. Okay?
I remember something like you go find something like, I remember I was looking for like, what was it? Just like a GoPro case. Like on the website for a GoPro it was like £40. On Amazon it was like 25.
Yeah. Exactly, because Amazon, yeah. I mean, that happens all the time. Whether it's good or not, but that happens. But if you're, say, the distributor, or if you're the retailer, you're not going to be too happy if Discount Phones moves in next to you, right?
But also, isn't that how it is for mobile phones? Because there's like really small, just like one-person shops that tend to also usually be cheaper. And although they do provide some service, it's not to the extent if you want to say O2, or like they have the whole teams there, they help you along the entire way.
Yeah, exactly. But what are these small one-person shops doing? They're in effect free riding.
Yeah.
Okay? They're in effect, because people know what they want because they've looked at O2's webpage. That they've perhaps gone to the O2 shop, right? They're free riding. Okay, and the more free riding goes on, the less of an incentive there is to provide these services. Okay, some manufacturers, particularly in the luxury goods industries, really don't want their goods distributed in these sort of cheap stores, because they view it also diminishes the value and the image of their product. Right? You go to Hermes, you want a nice Hermes scarf, you go to the Hermes store, right? Or perhaps you order it online from the Hermes dealer, and you know that you paid that price and the like. It's got that image. Nothing pisses you off more than if you bought something at one of these stores and then somebody else shows you the identical product that paid 70% less. Right? And manufacturers, particularly luxury goods manufacturers, know that. Okay, so they try to control that. Okay. So you want to limit competition, okay? Exclusive sales, you can allocate by territory. You can allocate types of customers. So hospitals versus universities, or houses versus warehouses, or something like that. Okay. Upfront access payments is one way of keeping it happy. Pay to stay or slotting fees in the grocery industry, which we talked about. Resale price maintenance. That is to say, if you want to sell this product, you can't sell it at less than. Okay? Think about resale price maintenance in that phone example. Right? If full service phone store wasn't, let's back it up. If the one guy operation who throws you the mobile when you throw in the money, okay, can't sell the mobile at a price less than the full service, you're going to stay at the full service, right? Okay, so RPM allows for a sufficient margin to support these sort of full service type stores. Selective distribution. Okay, selective distribution, picking out the type of stores that your goods are sold in. Okay, and this is often done with luxury and other branded goods. Okay, is another way of dealing with this. Okay, there are other ways, okay, of limiting competition between supplier and competing goods. The first set was between distributors of the same suppliers. So all of these would be, let's say, Coty Cosmetics or MAC Cosmetics, or something like that. Okay. Ways of limiting competition between your goods, okay, and similar goods made by other manufacturers. The Toyota Nissan case is exclusive sourcing, requiring people to purchase the brand exclusively from you. But that doesn't necessarily preclude purchase of competing goods. Non-competes in your vertical agreement. If you want to stock my goods, okay, you can't stock other goods. Quantity forcing, purchase a mandatory amount. If you want to stock my goods, you have to sell X number of, or you have to buy from me X number of units a year, a month, a week. Tying, if you want this good, you have to buy that good. Franchises is a good way of preventing competition with other brands. If you want to open a McDonald's franchise, you can't sell Whoppers, Burger King products. Okay, a lot of these are issues that really work and work really well in the case of dominance. And we'll touch upon most of these again when we talked about 102 abuses.
These are all legal ways. Like, are you allowed to do these things?
Well, yes and no. Okay. The reason I say yes and no is that at I do this not to be, a smartass, but it's just the way EU competition law works. Because first of all, EU competition law will look at the nature of the industry and product. So what's a yes in one industry, maybe a no in a different industry.
But for the mobile phones, is that?
For mobile phones, it's not going to work. Okay. And it's also going to depend upon relevant players' market shares, for instance, tying, and it's going to depend upon the clauses of the agreement. One thing that's not going to work in Europe is RPM, resale price maintenance. That is about as no-no as you can get in Europe. Okay? That's a no-no. It's yes in the U.S. It's not illegal in the U.S., but it's a big no-no in Europe. You do that, you get fined. Real simple. Okay? The rest, territorial and customer allocation tend to be looked on negatively, but there can be some efficiencies gained in customer allocation. Okay? For instance, a situation, suppose you have 2 alarm systems dealers in an area, fire alarm, burglar alarms, whatever. One of them, the company allocates homes to, domestic residences, where you and I live. Okay? The other one deals with warehouses. Obviously, there may be different needs, different ways of wiring these things, and so you have one firm, one part of the undertaking specializing in that behavior, in those customers.
I imagine that also works for depending on market, like for example, like medical supplies. Like if you build special hospital chairs, like the ones they use in operation.
Yeah, exactly. That's a sort of specialization, and you can get. There'll be. We'll turn to that hopefully tomorrow. Well, we will tomorrow to some extent when we talk about specialization agreements. Okay, so territorial allocation tends to be frowned upon. It's probably a big no-no in the EU, unless it's small market shares and somebody's moving into it, remember? Customer allocation probably tends to be frowned on, but less, because there's going to be some efficiencies gained. Upfront access payment is perfectly legal. RPM, really a big no-no. Selective distribution system can be done with care. We'll see that when we talk about the Coty judgment. Other ways, exclusive sourcing. This really depends upon the industry and the market power of those involved, except for franchises, and that would tend to look at the nature of the clauses in the franchise, and we'll turn to that when we look at the pro noctua case. I think I've already mentioned that briefly. Okay, this is a perfect time for a break. We'll turn to agency agreements. Agency agreements are discussed in the guidelines on verticals. They're important, so I would have a look at those as well. So let's take 10 minutes, and then come back.
either.
I'm gonna talk to Nicola tomorrow to discuss my title. Well, I could, like, I haven't pitched the title. That's the thing. Like, I have one idea for a title, and then the next one is like a mixture between competition and investment. Like, I was also thinking maybe, because I can't think of the talk, but like maybe competition and trading because they're also related. But I don't want to do my dissertation on trading. So we'll go and talk to Nicola and we can make some competition and investment.
They do this one.
I think
Good conditions and trade together.
I'm probably gonna have to miss the most lecture.
What kind of topic do that?
Because you can mix them because trade is also technically create forms of
Is this like celestial distribution?
yeah, we have a look at that. I have no idea. I think I might just go with my title. The thing is, I don't know if I can write enough on it.
Yeah, actually, it's
Yeah, because like, what I'm not talking about writing why you don't want to know that not on trading. That's the kind of thing.
I guess the question is, which profession you want to go into? Competitions or?
I will worry about that once I pick my dissertation. Because right now I don't have one. I think I'm gonna do an investment law. Like for investment law, I have a title. It's a mix between international public law and investment law. And I'm almost like investment and competition. I can't even think of the title, just the topic. Investment and competition. But at least for investment and international public law, I have no title. I just need to put the my title, see if it's a good title. B, if it works. C, if I can write enough on it.
Maybe you can use the career that's
Yeah. Build us a help me. I need marks. Well then, I would be there for the entire hour of the office hours. I need a title.
Evaluate your future course.
That's if you want to do it. Or just a multiple title.
First time is that they're particularly sensitive to we had to find out what's the difference between them and
What's your argument going to be?
yeah.
What's your critical analysis mean to be an argument?
Yeah.
And you can't just analyze it. Like, you need to come up with a point. Is it good? Is it bad? If it's bad, how do we fix it? If it's good, can it be improved? Critical analysis means absolutely nothing. Touching the exam. That's what. That's the juice bits. You should give an example. You should make a definition.
So I want to talk about why is that? Is that so one that serious just the benefit itself?
You should give a definition.
It's quite hard.
Yeah, 15,000 words.
Yeah.
Yeah, 15,000 words and 6 months. Yeah. Because you need to give things in one
I would not be able to do that. Very nice.
Yeah, I think the problem is nobody impressed me or teacher. I find it is these were like two different.
Because how you would do it, because you need to find a balance, because you can't see that to like, you can't perfectly do everything like that.
Yes, and
It's pretty long.
do you have an exact question? I'm just doing that. Well, I have, I don't like the two things, but I'm not my own presentation, I don't like.
You can't
Yeah,
just
but I don't know what to
balance
do.
between the two. You need to find
So
a
good, I
balance.
actually got it.
Both of them.
Exactly,
So then when you
yeah.
talk about that specific topic, you can look at it from different perspectives. Like, for example,
No. I'm not sure what I am. No, I'm just thinking about it. It's just one of that. It's a lot.
the same like that, right? It's too complex in one area. You can look at it from all perspectives. And all your opinions, you should be
How can you get around it's so busy, it's literally so and like, it's literally like everyone. When I like do it, there's so many people, literally, so many people. That's why it's like, you just sit so close, it's so I'm sorry
So we all back? Why don't we just push on and get out of here next time? Does that make sense? Okay. Agency agreements. These are probably the most useful. Actually, not the most. In one sense, they're the most useful form of controlling or means of controlling the distribution of the product, but because of their nature in terms of how much oversight and independence the agent has, they tend to be not as common as they could be. Okay, what's an agent? Okay, what is an agent in commercial law? Does anybody know? Does anybody have an idea? What?
Guys in the middle.
Guys in the middle, Mr. 10%. Yeah, exactly. A sports agent. Okay, what? You know, these football stars all have agents, right? What do these agents do?
If someone finds you work, for example,
They find you work, okay, and take a cut. Okay? And depending upon the nature of their agreement, they have the authority to bind you for contracts. Okay? So the Mr. 10% in sports actually comes out of a long tradition of commercial agents in the 18th and 19th century, where, for instance, a company, you know, this was of course prior to electronic communications, so you may have an agent in a particular country that was accessible only by a 2 or 3 week sail. Say you know your office is in London, you may have an agent in Canada, and it would take a few weeks to sail. But the agent would be there for and you would authorize your agent to enter into buying and selling contracts in those foreign ports. Okay, and your agent in turn would have the authority, the power to conclude contracts on your behalf. And this is what an agent is. Mr. 10% in the sports world. I say Mr. 10% because I think there's very few female agents. They're a legal or physical person vested with the power to negotiate and or conclude contracts on behalf of the other person. You know, the football star's agent has the power and authority to negotiate contracts with the relevant football team, or with the relevant firm who wants to use them to endorse a particular product. Okay, either in the agent's own name or the name of the principal, for the purchase of goods for the benefit of the principal or services. Okay? In effect, an agent is nothing more than as an alter ego. Okay? Is just a legal alter ego of the principal. Okay? Now, when is an agent a true agent, or when is an agent not a true agent? A false agent.
What's the difference?
Okay? Why? Because sometimes you may want to cook up a contract that looks like an agency contract, so it escapes the law, or so it hopefully escapes the law, but it isn't really an agency contract. Okay, where you're trying to disguise a wholesaler as an agent, so you can get around certain provisions of EU law. Okay? A true agent, whether an agent is a true agent or a false agent, depends upon the risk that the agent bears in relation to a commercial transaction. Okay? Three types of risk involved. Okay? The first risks are contract specific. But these are all in the vertical guidelines. Okay? Paragraph 14. Contract specific would relate to the concluded on behalf of the principal, such as financing of the stock. Okay? Agent negotiates a contract. Part of the risk of the contract will be payment or financing for the goods sold. Okay? The second type of risk in this agency is risks related to market-specific investments. Okay, these are specifically required for the type of activity which the agent has been appointed for the principal, which are required for the agent to conclude. Okay, the principal. The risks, okay, the market-specific risks that are incurred by both the agent and the principal operating on a particular market. Suppose the business is grain, you may want to have, for instance, a means of assessing the quality of the grain, right? Whether it's good wheat or bad wheat, or how many spider legs per 100 cc's of grain there are. Some market-specific risks. And then finally, the third set of risks are risks, okay, that the agent takes in going into business as an agent, right? The Mr. 10% has to open up an office, lease the office. Maybe he needs a car or a mobile phone. Okay, these are the costs of the agent doing business. Okay, now, okay,
There's the three's cost of doing business.
pardon?
It means like the cost.
Yeah, the cost of doing business for an agent, right? Agent has an office, agent has support staff. Okay, agent has a car. Okay, agent has a mobile phone. Agent has pens to sign. That sort of stuff, okay? Now, a true agency agreement, okay, means that the agent does not bear any of the first set of risks. Okay, the risks involved in the conclusion of the contract. Okay? A true agent doesn't bear any of the commercial risks involved in the sale of goods or services. Okay, the agent merely concludes the contract, okay, and doesn't bear any of the risks. Okay. 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 However, risks that are related to the activity of providing agency services in general, so the third set of risks the agent can take. Okay. The second set of risks is in relation to market-specific investments and in relation to the activity. Okay. So the first set of risks, no. The second set of risks, also no. The sunk costs involving in participating in a certain market. So for instance, if it's grain and you need a grain analysis laboratory, the principal pays for the grain analysis. Okay. The third set of risks, yes. Okay. Now,
So they only deal with the third risk.
the only risks that a true agent takes are in that third category of risks. If the contract, the so-called agency contract, requires the agent to take risks in the first two sets of first two categories, it's not true agency for the purpose of the competition laws. Competition rules. Yes.
Yes, should the agencies can make profit if the agencies can be successful in that situation?
Yeah. That's the third set of risks.
Can you understand that that kind of contrast is the specific kind of VAM evaluations, the valuation adjustment, merchant stuff?
Sorry, I'm not.
The valuation adjustments, merchant stuff. Is that kind
Valuation, that's irrelevant to what we're saying. Okay.
or I mean,
Okay. Now what? Okay. And a successful agent, why is a successful agent, okay, successful? Successful agent is successful because they conclude many contracts on behalf of it. Now look, there's nothing in one that says, okay, there's nothing in these three types of risks about the guidelines about how the agent is remunerated, how the agent is paid, right? Okay, so the agent could, depending on the risks here, the agent could be paid on a sliding scale. The percentages could go up or down, right? That has nothing to do with risk. Okay, so it's the risk of default here. Suppose it's defaulting upon a particular good. What would not count as an agency agreement is the following arrangement. Okay, the agent, quote unquote, concludes the contract, but is responsible for collecting the money and paying the quote unquote principal, right? Suppose I'm hired as your agent, okay, to sell goods to you, okay? Now, if this contract said I sell the goods to you, so the goods go to you, but I'm responsible for ensuring payment to you of the sum of money, that's not an agency agreement, right? Because if you go bankrupt or you abscond somewhere, I'm on the hook for it, so I'm bearing that risk. Okay? But if it's a good contract, my percentage of it is high. That's got nothing to do with the risk. That's based on the.
So is the first risk, contract-specific risks, born from the contract from the purchaser or from the contract itself of the agent?
Okay.
So what is the
Contract specific, no, not the agency agreement, but the agreement. Okay, there's
The
two
sale
agreements
agreements.
here.
between
There's the
principal
agency.
agents
Oh,
and agent and
right. There's the agency agreement. Okay, or the so-called agency agreement, and there's the sale of goods or services agreement. Okay, the agent, okay, is authorized to conclude the second sort of agreement. So the first agreement allows the agent to conclude the second sort of agreement. Okay? Now, in concluding the second sort of agreement, okay, none of these risks can be contained in that second agreement, in the sale of goods or services agreement. Okay?
So could you sort of like have like a risk in the agency agreement? And let's say, for example, you sold like marble goods, sort of rock stone, for example.
Right.
They said like like a ship it to you containers, like you must sell 1 or 2 containers a month. Like, is that's like a requirement? Like, would that not be a contract-specific risk in the agency agreement? Like, if you
No, that's not a contract-specific risk. That's basically saying that these are the terms of your employment as an agent.
Okay.
Okay, is that, you know, I only want agents that work hard.
Mm-hmm.
And you should be able to sell 2 containers of rocks a month. So, okay, that's got nothing to do with the particular contracts negotiated on behalf. That if she doesn't pay for her rocks, I'm on the hook for the rocks.
Okay.
Okay?
So that would be my job to chase up on like non.
Exactly. It's your job to hire the lawyers. It's not my job to hire the
You
lawyers.
got the sale, now I have to chase.
Yeah, exactly. Okay? Or I'm not involved in the financing process. Okay?
So that would give you those like staple contracts, that like sale contracts.
Yeah, exactly.
To you, which you could just give to them.
Yeah, exactly. Basically, I'm responsible for shooting business your way.
Okay.
Okay? So, now, this case, the CISPA case, involves a sale of petrol, where they were trying to expose what was really a franchise or a retailer's agreement as an agency agreement. The court's not interested, okay, on how the agreement is characterized. I mean, the agreement could say agency agreement at the top, or this is an agency agreement between X and Y, okay, and then goes to the court's not concerned, okay, about how the parties view the agreement, nor is it concerned about how national law characterizes the agreement. Okay? What it's concerned about is the actual commercial effects, the real-life economic operation of the agreement. Okay, the real economic situation, rather than the categorization. If the real economic situation imposes that first set of risks onto the so-called agent, it's not an agency agreement, irrespective of what national law would consider, irrespective of what the parties viewed it to be.
So they're looking at the real economic situation.
Exactly, how it works and how those risks are actually shifted. Okay? You can't disguise a false agency agreement as an agency agreement by calling it an agency agreement, right? The EU competition law looks at how agreements and practices all act in on the market, irrespective of how it's called. Now, agency agreements are very useful. Okay? If you have a true agency agreement, because your agent, okay, is your alter ego, is really just you wearing a different hat, okay, just acting in your shoes, okay? The agent can do anything that you can do, okay, or that you instruct the agent to do. So if I appoint you as my agent to sell a good at a particular price, you sell the good at a particular price. Because you are my agent, because you are my alter ego, it's not price fixing. Okay, you're my agent carrying out my instructions. You can sell it at the price I tell you to sell it. Okay? So a good way of establishing control over your goods is to appoint an agent to sell them. Okay? You can tell the agent how they're to be sold, how they're to be displayed, and at what price they're to be sold. And you can do that without breaching EU competition law. Okay? Couple of things that you need to be wary of. First of all, if you appoint somebody as an agent, you need to worry about ownership of the stock. Okay? They're there to sell it for you. They do not take title, they do not take ownership of the stock. Right? So you need to be clear about that. Your agreements. Also, insurance risk. Okay? Let's say I'm distributing exclusive water bottles. I appoint you as my agent. Okay? You store these water bottles in your shop. What happens if there's a fire or a flood? Whose insurance covers that? Anybody know about insurance law on that point? It's the principles, exactly. I have to maintain the insurance coverage. Okay, can't expect you to do that.
And then it's your product.
It's my property. You have no legal title, therefore no insurable interest. English insurance law is quite strict about that. Insurance companies like to weasel out of this stuff all the time. Okay? So you need to watch about those things, okay? But agency can be very useful. Okay? Suppose you're dealing with a high-end luxury product, you appoint agents to sell your product, make sure the insurance is set up appropriately, and then you can control exactly how the product is sold, and you can do so in a manner that's consistent with EU competition law. Okay? Very useful way of getting around it. Vertical restraints. Okay, okay. Vertical agreements and vertical restraints are used synonymous. Okay, we said why would they be useful? Special services, free wholesale services. Prevents the main argument is to prevent free riding. Look at the guidelines on paragraph 107 will tell you that guidelines on verticals is essential reading for the 5th time today. Okay? Okay, problem with vertical restraints, vertical agreements, okay, is that foreclosure of other suppliers. Okay, if you restrict, through some quantity forcing or through minimum purchase arrangements, you require your distributors or your retailers to sell a certain amount of product, that may prevent the product of other suppliers being sold by these retailers. Softening of competition. If, for instance, you have, and this is argued, if, for instance, you have resale price maintenance, that the prices are fixed, the retailers can't compete on price, so the parameters of competition, so the industry becomes less competitively. Another way of using vertical agreements is to use them to enforce a cartel among retailers. In other words, the retailers say, look, we really want to fix the price at X, but we can't legally agree amongst ourselves to fix the price at X. If resale price maintenance is permitted, the retailers can put pressure on the manufacturers to fix the price And therefore the retailers haven't agreed amongst themselves. It looks like it's been imposed by the manufacturer. There's a suggestion that the American case of Dr. Miles, which until 2007 made resale price maintenance illegal in the US, was a result of this sort of behavior. There's an argument that softening of competition, resale price maintenance may or may not soften competition among retailers. Rather, even though it softens price competition, the argument suggests that non-price competitive parameters, non-price parameters of competition are where the retailers or the undertakings will compete. For instance, prior to massive deregulation of airline fare prices, airline fares tended to be fixed, and every airline company would have to charge the same fares on the same routes, right? And probably this may have been before your time. Okay, so for instance, if you were flying, let's say long haul from Toronto to Frankfurt, Air Canada and Lufthansa would both charge the same price. Okay, for the same ticket, same price. Okay, but the airline companies would try to compete against each other, not on price on tickets, but on quality of service or cabin meals, or or through frequent flyer points or something like that. Okay, so and competition on those non-price parameters was quite vigorous. In fact, airline companies regularly went out of business. Okay. Back in the 80s, I used to do a fair amount of flying between Toronto and Vancouver. There were 3 airlines, and they all competed on service. Even in economy, you would get the, they come along and they put like a tablecloth, and the 3 courses all served at different times, and the cheese afterwards, and wine out of a bottle, and and this was just so 3 airlines. One of them soon went out of business, so it left 2. And then they were competing on frequent flyer miles to the extent where I flew twice, Toronto to Vancouver, and I had enough frequent flyer miles to fly twice again on business class. Okay, soon that airline went out of business, leaving us with one government, one not, but non-price competition and non-price parameters can actually be quite vigorous. Okay, softening of competition among suppliers. If you know what we're saying, fragmentation of the market. Some vertical restraints can lead to geographic market segregation. Now, the EU approach to vertical restraints of whatever sort is through the old object and effect based analysis. The key object-based analysis is the 2 focuses is market integration, okay, and absolute territorial protection. Okay, if you were to have, a vertical restraint that somehow fragments the market to the detriment of the consumer, this is viewed as an object restraint, and you remember from the analysis that we saw earlier, that's automatically a real problem. Leading case here, object restraints. Well, Constant and Grundig is always a good case to cite. Now, for instance, one of the object restraints was with Apple and its various Apple stores, even though it was one undertaking. Apple was viewed as committing a competition law violation by charging UK customers more for their downloads of iTunes. Okay, and then same thing with Nintendo. Nintendo was using vertical restraints to prevent the sale of its products from people. Nintendo was using vertical restraints to prevent cross-border sales of its games. Okay, it was fined. Well, it was reduced to 119 million euros. Okay, for this practice. Apple did a similar thing, but agreed to equalize prices. UK customers were paying 10% more. How was that happening? How did Apple know that you were a UK customer?
Is that kind of
Did you say you were?
Pardon?
Did you say you were a UK customer?
Well, there's two ways they were doing it. The IP address and your bank card. Okay, so even if you were in the Netherlands, okay, you try to buy it in the Netherlands, let's say, use the UK bank card, it would charge you the UK price. So if you were in the UK, it would know, because of an IP address, it would know it was charging you more.
So even if it was the UK but no UK bank card, it would still be charged UK price.
Yeah. So if you're a Dutch person in the UK trying to buy a download, you'd be paying a higher price. If you're an English UK person in the Netherlands with a UK bank card, you're paying a higher price.
Yes, but we do is nowadays like is the different price between the UKs and Americas. It's different price.
Well, in different prices between the UK and America, that's fine. Okay, nothing we can do about that. Okay, unless we have a common principle. Now you can probably no. Still, the law still applies. You have to have this. You can't have an unjustifiable difference in price between member states
Is that EEA?
within the UK and the EU. Correct. Okay. And the Commission is getting quite strict about this. Okay, what's been happening? Okay, is companies are using IP addresses to what's known as geo-block customers, and this is part of the EU's digital strategy. Okay, that came out 2 years ago. Okay. So the EU has prohibited cases through the use of technological measures or otherwise, block or limit a customer's access to the trader's online interface for reasons related to the customer's nationality, place of residence, or place of establishment. So in other words, the problem is simply this. Suppose I don't know, want to buy, let's say, a cuckoo clock. So I look at a clock manufacturer, and because I'm looking at the clock manufacturer from an English IP address, okay, the clock manufacturer takes me to their British page. Okay, and gives me prices and gives me terms and conditions there. But let's say I want to look at the German page because I think it's cheaper or something like that. The clock manufacturer, okay, what the clock manufacturer could do to make sure that I buy it from the English distributor is when I try to access the German page with an English IP address, it bounces me back to the English, to the UK website. Okay, that's prohibited. I've got every right now to go in and look at the German page, and if I want, for whatever reason, I'm entitled to order from the German manufacturer. Okay. Maybe because I don't like the exchange rate on euros, maybe because the German distributor has different clocks, whatever. Okay. But I'm entitled to order it. Okay. So I can't be blocked. The trader, okay, shall not redirect, okay, to a version of the trader's online website that is different from the online interface to which the condition customer normally sought access. So if I seek access to the German website, I'm not supposed to be redirected to a UK website because of my nationality. By virtue of its layout, use of language, or characteristics specific to residence, unless the customer is explicitly consented. It has to ask me. We notice, for instance, I go to the German website, it has to ask me, we notice you are coming to us from a UK address. Do you want us to take you to the UK website? Yes or no? Okay. Now, the problem is that often geo-blocking has been used, particularly in the, time and time again, to fragment the market. That is to say, some large company gives a exclusive distribution to another company to distribute the first company's products. Okay, and in order to enforce it or to enhance this distribution, the larger company agrees to prevent, okay, people from within that geographic area accessing websites outside of that area. There have been about 6 cases in the past 18 months where the Commission has fined undertakings for this sort of behavior. Everything from Adidas type running shoes, runners, trainers, to Disney type products. I don't think Disney was involved, but other companies with the movie franchises products. Okay, making that difficult. Okay, now the core principle behind all of this, okay, is a principle that was announced in one of the first important EU competition cases, Constant and Grundig. Okay, this involved in the 1960s electronics items, radios, and Constant and Grundig were attempting to, in effect, say German dealers could only sell to Germans, French dealers could only sell to French people. And so therefore a French person, we weren't going to allow a French person to cross the border into Germany to buy a radio in Germany. 2 principles in Constant and Grundig. The first principle was the was a discussion of horizontal and vertical agreements. Constant and Grundig said Article 85 only applies to horizontal agreements. It exempts vertical agreements. The court listened to Constantine Grundig's argument and said, in effect, show me where it exempts vertical agreements. It says all agreements. Okay? So horizontal and vertical agreements are treated similarly by the treaty provisions, and Article now 101 applies to both horizontal and vertical agreements. The second point is the market integration goal. And in effect, this was the first of the Commission's goals. The first one was to integrate the market. The second is protection of consumer welfare. Now the third goal, it seems to be, is breaking up or controlling digital monopolies. But in the 60s and 70s, the Commission and the Court's focus was on market integration. And the market integration element of the treaties and the competition provisions within the treaties. And it pointed out that vertical agreements could be of the sort of agreements that could be used to, as they say, restore the national divisions. Okay? In other words, vertical agreements could be used by private undertakings to restore trade barriers between member states. Okay? We want to break down governments using the use of trade barriers by governments so as to encourage the cross-border flow of goods and services. We're not going to allow private parties to reestablish these same barriers because they can have the same effect as government-imposed divisions and therefore be equally as frustrating to the community goals. Okay, so important case on vertical agreements. Okay, at this point we will take a break. Now, as an aside, a lot of the analysis of the nature of vertical agreements is on the object and effects basis. So I propose tomorrow to go through the first series of slides on that fairly rapidly because we focused on the nature. And then I will turn to other sorts of agreements, and then we will have time near the mid to end of tomorrow's lecture to deal with the block exemptions. There's a lot of material on the slides. I'm not going to go through all of it. Okay, it's there really for reference. What I propose to do is to go through one or two examples and showing you how the block exemptions work. Two things, okay, for the purposes of an exam, when it comes to block exemptions, you will see that when I talk about revision, the flowchart, you'll have to mention block exemptions, okay? So you should know what they are, know that they exist, and for the purposes of the exam, be able to say that none of them apply. Because I can guarantee you, in an exam situation, none of them will apply. Right? Because if they apply, that ends the question. And half the fun would be over. Right? Think about it from my perspective. Okay? So, now, but for private practice, okay, block exemptions are important. So you need to know that they're there, where they are, how to find them, and have a general idea of how to apply them. We're in a situation in private practice. You'll need to read them very carefully and look at the latest guidelines. And just because, okay, you've got block exemptions, there's a few block exemptions in this book, general block exemptions, but there's a third volume that I haven't mentioned of specific block exemptions for specific sectors. But trust me, you've got much better things to do in your life than read through. But know about their existence, know where they are, and if your client is in that sector, know where to find them. It's in the third volume, the one that you didn't have to read. Okay? Okay, so that's the plan for tomorrow. Okay? Have a good but albeit wet day.
I also have a question. How can define the same level in there? How can define the same level with like for example, I have to buy some materials and sand and water.
Right, so they're the higher level.
So at the same level.
No, different level.
Higher level.
Yeah, because that's your input. Okay?
Yes, input.
Input to your goods. Okay, so when you, the concrete is over so you mix the goods. And the person below is using the buy them. Okay? So it's think about the production, the manufacture of the system. Okay?
Yes, but I have another question. Like, if I have to make another, I just made another wider. Are they just the same level?
An agent is always at the same level as you are because it's just you wearing somebody standing in your shoes. Okay, so the agent is always at the same level as you are.
But the insurance providers.
Insurance providers, it's a higher level because you don't sell to them, you buy from them. Okay, it's like one of the inputs.
Like the connections and inputs are out.
Yeah, exactly. Inputs would be higher than outputs. Okay, I love it. Okay?
Thank you.
If I want to buy the Zara clothes on the EU website, but it's blocking me to access the EU website, and I got into the UK website.
Right.
Is there any way that I can report it?
Competition and Market Authority.
So I can email this kind of situation.
Yeah.
Oh, that's great.
Okay.
I encountered the same
Yeah.
this situation several times.
Okay, yeah, no, they're supposed to
I will
be
try
doing
it.
Yeah.
Will they respond me?
It's how busy they are. So,
Okay.
okay?
Thank you.